We are organizing the Italian intellectual property appeals, which are aimed at explaining how to enforce intellectual property rights in Italy. Not surprisingly, we will commence our analysis from the search and description order. Search and description orders are a very effective tool to protect intellectual property rights in Italy, and they are peculiar, meaning they are not available in many other jurisdictions. An application for search and description order may be filed by the applicant also when the right has not been granted yet. In other words, with an application for trademark or for patent. And also may be filed by the owner of a de facto trademark or the owner of know-how. The application is filed before one of the 20 specialized IP courts in Italy. The applicant needs to demonstrate that he is the owner of a valid right and that this right is infringed by the alleged infringer, and also have to give some elements about the danger in delay. It is very important to provide reasons why the order shall be granted ex parte without scheduling a hearing, a discussion hearing before the judge. This is often related to the fact that if the defendant was previously informed of the existence of the proceedings, will not allow the collection of the evidence, but if the product is available on the market, it may be more difficult to obtain the order ex parte. If the order is granted ex parte, it allows the bailiff, a court expert if there are technical issues to be solved, and possibly the applicant, to raid the premises of the defendant. The defendant will not be informed in advance of the arrival of the people participating to the raid, and they will therefore ring the bell and show up and collect evidence of the infringement. The participant to the raid will search the premises of the defendant and try to identify the infringing items, so they can collect samples of the infringing goods, but also they will take pictures of the infringing processes. They will take copies of the accounting records of the defendant. Any evidence, advertising material, drawings, any evidence, technical documentation, advertising documentation, accounting documentation that can be useful for building ordinary proceedings on the merits will be collected in that occasion. The only thing is that the order, the judge, in granting the order, may provide precautions to protect confidential information of the defendant. For example, the sensitive documentation, the accounting records, for example, or some technical documentation, is included in a sealed envelope and will be, which will be opened at a later stage of the proceedings. The minutes of the operation, together with all the evidence collected during the raid, will be filed by the bailiff with the court that granted the IP order. The applicant has then 30 days, a 30 days deadline to commence ordinary proceedings. Otherwise, the evidence which was collected in the raid cannot be used in the future. the evidence can also be used in other proceedings, for example in precautionary proceedings, preliminary injunction proceedings in Italy, but also abroad. So if you need to commence preliminary injunction in Germany and there is a manufacturer facility in Italy, you can collect evidence of the infringement in Italy and use this evidence in Germany. So why search and description orders are so important in the Italian system? We have said that part of the reason is that it's something that you cannot find in other jurisdictions. Many other jurisdictions do not know this mean of protection. But another reason is related to the fact that Italian proceedings are, as you know, considered slow and lengthy. And if you get it right, if you collect good evidence of the infringement, you have a strong leverage to obtain a settlement agreement in an earlier stage of the proceedings. DLA Piper worldwide is very active in the protection of intellectual property. In Italy we have a dedicated team, and if you need us, we will protect your IP assets in any moment.